In this video, I want to look at the 5 scenarios that was in the Chief Counsel of the IRS memo on supply chain disruption. So this is kind of, Chief Counsel is like the attorney for the IRS. We got these 5 scenarios, mainly dealing with what I call FAQ, they call it Q&A 12. And out of it, they've kind of translated that one question number 12. But what the focus is on this is to look at whether you, the small business, or if you're an accountant, tax person representing a small business, what you're going to do. We're going to go through certain scenarios. We're going to look whenever they're in a government shutdown. Then we're going to look at when they're not in a government shutdown, and we're going to focus on the supplier, the supply chain disruption. I testified last Thursday before the House Ways and Means Oversight subgroup, and my section was on all the fraud that's on the internet. And you got the indicators, 15 to 30% fees and all that. But I think what you have to go through, even if you're innocently trying to qualify, you're working with a tax pro, I think these scenarios really explain the law very well and show you how narrow the definition of a supply chain disruption is. So let's look at scenario 1. Don't like to read, I'm not going to read every word of it, but we need to at least look at it. Employer A was not subject to government order limiting commerce. So that's the definition. However, during 2020 and 2021, experienced several delays in goods from supplier 1. At all times during 2020 and 2021, employer A continued operations. So we continued operations. Remember, in this case, they were not subject to a government shutdown. So they're going to try to get the ERC credit based on the supply chain. Employer A assumed that supplier 1's delay in delivering critical goods was caused by COVID-19. Employer A inquired, and supplier 1 vaguely confirmed that the delay was due to COVID-19. Supplier 1 did not provide a government order from an appropriate government authority, and employer A was unable to locate one. Let's just stop and use some business sense right here. This whole thing smells. Because in our videos we've been doing, we know first thing, you have to document. So I've referred to this before, but I went out to I took one of my companies that I own, and I went out to the state of Missouri, and I found out we had a government shutdown from the middle of March, around March 13th, through May, I don't remember, 5th or 6th, but it was just about 2 months. And at that point in time, I was covered by PPP, and I couldn't double dip. My point is, at that point in time, then I thought, well, let me check out supply chain, the supply line shortage. And so I started shopping the internet. But here's the takeaway, which happens so often. When I was making these calls, the person on the other line wasn't saying, I need to get an appropriate government authority of it. I wasn't being told that that I need to document it. As we saw in the law a while ago, it appears to me to be, I'm not doing anything right. So, but in this case, the only thing we'll focus on, I did not have proper documentation. I assumed as that small business that supplier 1 was under a COVID-19 shutdown. What do you want to guess the answer is to this? No. So, and why I kind of paused there is that when I was going through shopping these mills, they never told me, they never talked to me about a government shutdown. They never told me that the wages, if it was one, and I could qualify this way, it was when wages started under the mandate date and ended. So if you have already got ERC, and for sure if you wasn't under a mandate, which in rural areas across the country, there was a period in 2020 sometimes a couple months, sometimes a few months. In certain urban areas, it went on for quite some time. But this is really focused on, I'm not under a government mandate shutdown. As a result, it's going to be very hard for me to qualify under supply chain. And in this case, when we look at the analysis after a while, my guess is scenario one is a no. No documentation. Whoever assisted the small business in filling this out didn't ask the right questions. So now let's look at the conclusion that this memo came to after looking at scenario one. There was all these assumptions. So let's see if our discussion agrees with the author. Employer A cannot demonstrate that the government order applied. Didn't ask the right questions. The conversation was vague. Couldn't demonstrate. So I can see the answer here is going to be no. Even if employer A, coming down to here, received or could have located a government order applicable, employer A did not cease operations. So what I see here in the conclusions or the analysis, it says employer A did not cease operations because it had reserve or whatever reason. So did not exercise a full or partial suspension of operations. So what we're seeing here is that employer A is just striking out. The relevant inquiry is whether the employer A was able to continue its own business operations despite the supply chain disruption. It was not subject to a full or partially suspended operation. So scenario one, the takeaway here is one, you better make sure the supplier is in a government mandated shutdown. Not because they couldn't get people to show up to work or whatever, but they have to demonstrate that the supplier was in a government order. They didn't do that. They didn't do the right inquiries and not the right documentations. So let's go to scenario number two. Employer B was not subject to a government order. However, certain critical goods, the supplier was stuck at a port in state X. So it was stuck at a port. Employer B assumed, well, you can't assume when you're trying to file for this credit. They assumed the bottleneck at the port was a result of COVID-19. Employer B could not identify any specific government order applicable to supplier 2. So couldn't identify. So we have no proof and no documentation of any government shutdown. Going on down. Some news sources stated COVID-19 was the reason for the bottleneck, while citing such an increase in consumer spending and aging infrastructure. I don't hear the government mandated shutdown. Supplier 2 mentioned to the employer that other critical goods were not stuck at the port would be delayed due to a truck driver shortage. A truck driver shortage is a business problem. It doesn't say COVID-19. Employer B saw some discussion on social media that truck driving shortage was because drivers were out sick due to COVID-19. You notice here, we're making assumptions. We're thinking because somebody told us we think this. If you have applied for this credit or you're thinking about applying for this credit, this scenario says when I apply for a credit that I don't qualify under the gross receipts test. We're not discussing that in this video, but I am using other than the mandated shutdown that my business is under. We have to realize we probably don't qualify for the credit. Now that we've looked at scenario 2 and we've done our own analysis as we did with 1, let's go over and see what the author thinks about scenario 2. And looking here at the bottom of the page, scenario 2, employer B does not meet, right there, does not meet the definition of an eligible employer because B cannot demonstrate a government order applies to supplier 2. So in this one, we see, as we talked about in our discussion, supplier 2, we can't prove that they were fully or partially suspended. Look here, it says, in addition, while COVID-19 may have contributed to the bottleneck, so it may have contributed to it, but it's a fact that it didn't raise to the level of causing the employer to be shut down themselves. Employer B could not substantiate that any specific, and like here's the key, is that there were several government shutdowns going on, but the employer B had to prove that supplier 2 was the reason for the bottleneck, and the fact that supplier 2 was not documented, and then having the truck also, they didn't inquire to that level of the bottleneck, because as whenever we discussed it a few minutes ago, it was the fact they heard it on social media. So we can't just believe in what's on the TV. We can't, if the mayor comes in and says, hey, we'd like everybody to social distance, that's not a mandate. In this case, employer B was unable, both with supplier 2 and even with the trucking company, prove or raise the bar is very high. Raise it to the level that supplier 2 nor the trucking company actually created an impact to the level on employer B. Scenario 3, employer C. With supplier 3 are located in a jurisdiction, so in a jurisdiction, it appears to be they're in the same jurisdiction that issued a governmental order suspending both of their business operations for the duration of April of 2020. So it's for April 2020. Employer C and supplier 3's jurisdiction lift all orders related to COVID-19 in May of 2020. Sounds like they're in the state of Missouri where I live. For the remainder of 2020 and 2021, employer C experiences delay in receiving critical goods from supplier 3. Supplier 3 does not provide a reason for the delay, but employer C assumes the delay is, here's that word assume again, because of a government order placed into place April, look at that, assumes, right here, assumes the delay is due to a governmental order placed in April of 2020. Can't assume. And here's the neat thing about this one. In scenario 3, both employer C and supplier 3 are located in a jurisdiction that they issued a government order. So I thought it might be the same one, but it appears there's an implied statement it may not be the same one. So whenever the one ends for employer C in April, employer C never gets any more documentation and says, wait a minute, I have a supply chain disruption, but the mandated shutdown period was for supplier 3 didn't check on it. So if it ended in April, the rest of 2020 and 2021, nobody qualifies for the ERC. So this one here I really like. It's if it's in the mandated shutdown, it qualify. And the big reason why in all these, this one here, they were required shutdown. Employer 3 was no longer shut down, but continued over the next couple of years to have this delay in receiving goods, but never checked with the supplier to see when their mandated ended. So what would happen, and we're going to find out later, what would happen is they may qualify if, so let's say supplier 3 kept for all the quarters was in a government shutdown. We're going to find out later there's another test. It's one thing to say that it's because of the supplier's shutdown, but in the analysis that we did a while ago of the law, we realized that the supplier's operations had to cease or be impacted, and that employer C would step in the shoes of the supplier. Not good news after employer C was no longer under the mandate. Now that we've looked at scenario 3, let's see what the author has to say here. Employer C is an eligible employer in the second quarter of 2020, as in the given, because it was in a business operation where it was fully or partially suspended due to a government order. However, only the wages paid with respect to the period in which employer C is fully or suspended due to a government order may be considered qualified wages. Well, that was part of our analysis. Remember when I said just a minute ago that it's from the date the mandate shutdown started until a required mandate shut until it finished. So we know that on qualified wages. See, because on the gross receipts test you qualify by quarter, here qualified wages is only during the time period of the mandated government shutdown for C. But I think the bigger takeaway here is down here in the second paragraph on employer C. Does not meet the definition of an eligible employer. Here's that question 12 appearing. That's so again, as I've said many times, when you see Q&A 12, that deals specifically with a supply chain impact on our employer that will raise to the bar of a government shutdown. So it does not meet for any subsequent calendar quarter in 2021. What they're saying here is we qualified for the second quarter, employer C did, but there was no mandated shutdown. There may have been, but employer C didn't even check with the supplier, made an assumption that it continued. So as a result, employer C cannot demonstrate that a government order was applicable to supplier 3, which would have caused a government order or a complete shutdown. The point of this one is that employer C, even though they both started under a government order shutdown, employer C did not go back and say, when did that mandated government shutdown happen? But also remember, when we analyzed the law, we'd also had to, see that the impact. So if there would have been a government order shutdown for supplier 3, then employer 3 would have had to demonstrate or show not only that government shutdown happened, but it was to an impact that it partially or fully suspended its operations. And again, that definition is in the law that we did in the first video here. So go back and see it, please. It's going down to number 4. Employer D was not subject to any governmental order, same to COVID-19, so it was not subject. During 2020 and 2021, employer D could not obtain critical goods from supplier 4. However, employer D was able to obtain goods from an alternative supplier. Oh, this sounds like good news. The critical goods from the alternative supplier cost 35% more than from supplier 4. Employer D could continue operating trade or business even though it was not profitable in 2019. What do you think the outcome on this one's going to be? I think they don't qualify because when we analyzed it, one, the supplier had to be in a government mandated shutdown, but one of the other tests was could you get the material, could you get the supplies from an alternative source, in this case an alternative supplier? The answer is yes, but a lot of times you hear, well, it costs me more. You're still in business. That's a business decision, not a COVID-19 decision. Now that we've looked at scenario 4 and had our discussion, let's see how close we were to being on point. Employer D does not meet the definition, so it does not meet the definition of an eligible employer under Q&A 12 because D could not continue its trade or business operations, and D was not prevented from operating its trade or business during that period. Incurring higher costs for goods does not result in a partial suspension. So the key here is that, as we saw in the law in the first video, is that you have to look for other supply. So just because you can't get it from your supplier, you have to see if you can get it from other suppliers. And in this case, they could have they continued their business, was it 35%? So critical goods from an alternative supplier cost 35% from supplier 4. Employer could continue operations. So it wasn't, it was a higher price, as we said in our discussion on scenario 4. That was a business decision. So if it's available, then you would continue operations. Look at the final scenario. Scenario 5. Employer E operates a large retail business selling a wide variety of products. Employer E was not subject to any governmental orders limiting, that's the general definition of COVID-19 in a governmental order. Due to various supply chains, and he doesn't run it, disruptions, Employer E was not able to stock a limited number of products and was forced to raise prices on other products that were in limited supply. However, at no time did the product shortage prevent E from continuing a fully operated as a retail business during 2021. I think in that case, what we're going to find out here is that it was the fact that because they could continue operations, then they don't qualify for the ERC. So here we found out because of various, the takeaway here in 5 is various supply chain disruptions. So there was supply chain disruptions, but did it raise to the level or the requirements, or did it raise to the bar of frequently asked question 12, which we saw over when we analyzed? That was not in the CARES Act. That was actually in a frequently asked question with a very limited scope. So I think this one right here, I've got some clients this comes under. I don't believe they'll qualify. Well, let's see if our discussion on scenario 5 kind of agrees or disagrees with the author. Let's look. We got employer E does not meet the definition. Let's just stop right there. Scenario 3, I believe, was only, they qualified, out of these 5 examples, scenario 3 qualified in the first part, but they qualified because they were under a mandated government shutdown as an employer. But each one of these cases where that we looked at a supply chain disruption under Q&A 12, we find out that we've not met any thresholds here. But let's continue on with the author's analysis. Employer E does not meet the definition of an eligible employer during the year 2021 because the employer E cannot demonstrate the government order is applicable to the supplier of critical goods and materials because the supplier that caused the supplier to suspend operations. So see, it did not cause the supplier to suspend operations, and that E was unable to obtain critical goods and materials, causing a full partial shutdown of E's business operations. So this is kind of that step in the shoes when we looked at the analysis of the law. It says at all points during 2021, employer E was able to operate his retail business. While a limited number of products were unavailable, employer E was still able to offer a wide variety of products to its consumers, and E was not forced to partially shut down its operations. You know, I think this one here is the most straightforward to a lot of my retail clients. So I kind of want to do this one again just a little bit. More importantly, does not qualify because E cannot demonstrate that the government order applicable to the supplier of critical goods and materials caused the supplier to suspend its operations. See, when we were looking at the analysis, that was key. It did not cause the supplier to suspend its operations. And that that employer E was unable to obtain critical goods and materials, so they could look for third party, etc., causing a full or partial suspension of employer E. So that's kind of that step in the shoes we saw in the law. So the takeaway here, again, this scenario 5, if you're a practitioner, I think, you know, if I was looking at these, I think 5 is a good one because that's your retail stores, and just because they couldn't get certain things, they still continued, and the supplier here, again, circled, right? Let me put, where's that pin? Put it right here. It did not cause the supplier, because see, whenever employer E steps in the shoe of the supplier, then technically the supplier would look out, which would be the employer, and say, well, I can't buy critical goods. But as we saw in the law, in this case, when you step in those shoes, there's a higher level. It appears to be the IRS is saying that supplier operations had to cease in order for me to qualify. So again, I've kind of hit number 5, but I think it's the one that I see the most of. Stay tuned. I'll later do a flow chart of how to make this decision, and if you've already got the PPP, I'd recommend you attend that little short presentation. It's a summary presentation that's going to include this new memo. And with that, I'll see you over on the decision tree with the new Chief Counsel memo, July 31st, 2023. Thank you. See you over there.